to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, murder, or aggravated battery against herself. The crime of murder is defined as the intentional, unlawful killing of another by an act imminently dangerous to another and demonstrative of a depraved mind without regard.
This is a live look inside of the courtroom in Ocala, Florida, in the case against Susan Lorincz. It's a manslaughter trial. You heard the judge there talking about a killing with intent, but that would result in great bodily harm. As far as the reckless conduct, not an intent to kill, not an intent to murder, but this is a manslaughter trial. She faces up to 30 years in prison if she's convicted. Police say that the shooting victim in this case, 35-year-old Ajike Owens, was banging and knocking on Susan's front door when Susan shot and killed her through that door, but they say this was unwarranted, that she should not have shot through that locked door, that it wasn't a reasonable fear for her safety. The defendant, however, says she was in fear for her life and that Owens was threatening to kill her when she shot through that door. Before we get back into the courtroom, because you hear there, the judge is giving the jury instructions. Closing arguments haven't begun yet. So let's take a look back at some of the biggest moments from the defense's case yesterday.
Considering where the cartridge casing was found, can you tell us where Ms. Lorincz was when she shot the firearm?
Yeah, it's my opinion that she was probably standing in front of that countertop, not in the kitchen, but yeah, maybe like in this photo here, near the table and chair. I would put her out, you know, as far as I feel comfortable extending her out away from the kitchen and towards the door would probably be about 10 feet ejection pattern.
If she was standing in front of the kitchen, close to the little table and chair area, how did the cartridge casing end up in the kitchen area?
I think the most likely scenario would be that it bounced off that painting or that wall.
You're talking about this painting right here?
Yes.
Okay.
Yeah, I think it would have likely bounced off that. It's hard to be 100% sure.
In this specific case, were there any close range gunshot residue drop-offs?
I didn't see any residues in the photos, and I didn't see anywhere in the crime scene notes or report where they were mentioned.
And there weren't any present on the door?
Not that I could see.
Based on your analysis, the defendant did not fire from back here in this hallway area.
Correct. I would agree with that.
You would agree that the defendant did not fire from behind this kitchen counter at all. You would agree with that?
I would agree with that.
It's your opinion that the defendant fired from somewhere, I guess, like around here, or maybe even further back towards the kitchen.
Right, I can't be exact, but I think she was far enough back that that cartridge case would have landed on the countertop.
And you would agree that that's your opinion, but you did not visit the scene in this case, correct?
I did not.
You would agree that you did not inspect the gun used in this case, correct?
I did not.
And you would agree that you've never even fired the Remington 380 model that was used in this case, correct?
I do not believe I've ever fired an RM 380 now.
And you would agree that you did not inspect the shell casing in this case?
I did not.
And you would agree that you did not do any testing of the physical evidence in this case?
Yeah, I didn't examine any evidence in this case, except for the photographs and the visualizations I was given and the reports.
Ms. Lorincz, have you discussed with your attorneys the decision regarding whether or not you will testify or not?
Yes, I have.
Do you need any additional time to discuss that decision with them?
No.
Have they forced you to make a decision in any way?
No.
Have you made a decision on your own?
Yes, I have.
Can you tell us what that decision is?
I am not going to testify.
You've made that decision freely and voluntarily?
Yes.
Now, with that statement by the defendant saying she was not going to testify, we had the defense rest. The state did not go forward with any rebuttal evidence, and now we're at the time of closing arguments. Jury instructions are being delivered to this jury right now, and we are standing by for those final summations to begin. Let's bring in our guest for this hour. Former prosecutor and criminal defense attorney Randolph Rice is standing by with us. Randolph, we've got a situation here where the defense wants to make her closer to this door rather than further back. The prosecution says that she was behind this kitchen counter when she fired the gun, but the defense says she was much closer to the door. Farther or closer, does it make a difference when we're talking about reasonable fear of deadly harm?
Julia, I think it certainly does. And what's interesting about as we heard the instructions from the judge there, the state has to, and I pulled this Florida law, the state has to show a death caused by culpable negligence, which would be an order for negligence must be gross and flagrant. Now, the defense is going to try to argue, though, that this was a justifiable action, that she did this as justifiable. And putting her closer to that door may give her that heightened level of fear. You noticed in the interview room video we saw earlier in the trial that she kept saying, I thought she was going to kill me. I believe she was going to kill me. Putting her closer to that door would raise that level of fear that she may be killed if that door is ultimately opened and Miss Owens would be able to attack her.